We have we have over 110,000 tribal members. We are the fourth largest tribal nation in the United States. We have recently, with recognized um, our recognized reservation, we now have 3.3 million acres that is reservation land, and it includes the majority of Tulsa. As was mentioned in the quick little intro, the McGirt decision has been significant, not only for the Muskogee Creek Nation, but for the five tribes who were previously known as the five civilized tribes. The five tribes have each subsequently had their reservation land recognized, as has Quapaw, Wyandotte. I think there are a couple of others in the northeast quadrant of Oklahoma in Mr. Stan's area. Um, it has had reverberations that have affected tribal nations throughout the United States. Now, that not only was that an historic win, there's a little bit of background with it. We have what was known as the canons of Indian law starting in 1830. There were the Cherokee cases that were in Georgia at the time of the newly established United States and the Supreme Court, and all of that formed with three cases that formed the initial backbone, if you will, of what was recognized as federal Indian law. And it didn't stop there. But from the early 1830s, with those cases, unfortunately, there was also a lot of trauma history that the five tribes, were forcibly removed to Oklahoma on what is referred to as the Trail of Tears. And I say that because currently there are 38 federally recognized tribes in the state of Oklahoma. I believe only two or three were indigenous to Oklahoma. Mr. Sand and many other tribes, we were sent here from our homelands. And then an interesting part of Oklahoma, there were already tribes here. The Caddo, Wichita, the Kiowa, the Osage and Tonkawa. Some of them had migratory history through Oklahoma, but we were kind of sandwiched on top of indigenous people who were already here. But from our removal to Oklahoma, where the was established that language, you have this land as long as the grasses grow and the waters flow. Well, that didn't necessarily ring true. When I was growing up, many tribal people we go to school, we go to public school, and we learn history, we learn civics, and etc. And then, yet, when we go home, there's a different education that we have. We have an education about our leaders, our history of who we are, our creation stories. And so it was a different history that was not being taught, and kind of ran parallel with what we learned in the public schools. Much of that being our treaties were broken. The US government lied. There have been multiple attempts for ethnic genocide of Native peoples, and yet we're still here. So growing up with that mentality, and I personally, my grandfather was on our national council, and I recognized early that there were three governments in the United States. There was the federal government, there were the states, and there were tribal governments. And so recognizing the responsibility of tribes and that sovereignty was very important for many of the current generations who now make up Indian country. So we've known that there were treaties, and that those treaty rights were ignored, were flagrantly um, uh, broken. So when the case of McGirt, and I hate to refer to it as McGirt. We often call it the reservation recognition, because McGirt was a very ugly case, and that came at the heels of another case that was similar to it that Justice Gorsuch had to recuse himself from, and that was Murphy. And Murphy, it was a heinous sexual assault, homicide, and McGirt, he sexually assaulted his granddaughter. Horrible. And I hate to give his name any credit to anything positive, but it is where we are. And so if I refer for it from here forward as the reservation case, you'll have an understanding of what I'm referring to. But in 2020, this matter came up with a collective of attorneys. One of the few times I've seen prosecutors and defense attorneys really work together, because I think we have different blood types and different ways of thinking. However, for the purpose of treaty rights and looking at what had happened with the history of the state of Oklahoma and the Muskogee Creek Nation, there was a lot of momentum and very intelligent attorneys who got together. And I would put my hats off to Riaj Kanji, who is our appellate attorney and appellate law firm on this, who made the argument before the United States Supreme Court and did a very excellent job. And we waited for a little over 2 years for the decision to come back. Once oral arguments have been made, you wait and for that term when they start releasing opinions. But we had to wait another 2 years, and you never know whether that's a good thing or a bad thing. But in that time, we recognized, be careful what you ask for, because you just might get it. But it was the right thing to do, and we're very, very, we're very proud of the decision that was written by Justice Gorsuch, which began with, at the far end of the Trail of Tears, was a promise. And that goes to the treaty of the Muskogee Creek Nation that was dishonored by the United States. And on top of that, the state of Oklahoma just acted like it wasn't even a thing. And throughout those actions of both the United States and the state of Oklahoma, the Muskogee Creek Nation had been told so frequently and through the allotment process that we didn't have a reservation. It went to individual land ownership. It was the trust and restricted status. And we had checkerboard of what was originally our reservation. There was only a small fraction of that that was ever that was used or could be claimed by the Muskogee Creek Nation. With the restoration of our reservation, and also recognizing Osage Nation had for years have filed suits with the federal government to have their reservation recognized, and it has yet to be. Osage Nation is not currently recognized as a reservation proper. But there are several other tribes in Oklahoma that have recognized what's going on. And just like many of the other five and others have had their reservation territory recognized as never being disestablished. So, so that's part of the a quick little background as to where it has led to January 9th of 2020. And that is a day in time for Muskogee Creek Nation that we recognize that as our reservation day. Now, there's always different levels of things that work in practice, and we all function in the same reality, but how it's looked at and how it's realize can often be different. So the United States Supreme Court rendered their decision in McGirt. The Muskogee Creek Nation began to immediately start working. At that time, the Attorney General's office had 4 prosecutors. And in 2019, this office processed 46, I believe, 46 criminal cases in 2019. And at that time, there were approximately 20 light horse officers. Our police are referred to as light horse. And that's a traditional connotation that our people were fast and swift on horses, and they were light on their feet. So they became historically known, and that name continues, that our law enforcement is light horse. So light horse at that time had approximately 20 officers. Since McGirt, and in 2023, my office processed over 6,000 criminal cases. We now have over 140 light horse officers, and they're still hiring. My office went from 4 attorneys to 24, and I'm still hiring as well. The need for not only attorneys who have experience and understanding and a heart for federal Indian law and tribal law and justice was great, and but it was also everything broke loose. There were boxes of cases that were sent from Tulsa, from Muskogee, from many of these larger jurisdictions and municipalities, sending the cases over, saying, you wanted it, here you go. And everything from traffic tickets, and some traffic tickets, to homicide. That's what we have gained. In the first year after the decision, I think that it has been described around here as drinking from a fire hose. But I was hired in the early part of in 2022, and since then, that's when a lot of the changes. And I'm really thankful for my background and experience of prosecutions in Indian country to be able to, and the Marine Corps, to be able to establish teams, how we're going to divide and conquer the multitude of cases, because failure is not an option for us. We owe this not only to our tribal citizens and to Native people who live within our reservation, but to other citizens who just happen to be here and wake up, and they are now living on the reservation in the Muskogee Creek Nation. He's out. He just left office, but the Tulsa mayor at the time, we were given comments at a presentation, and he was going just before me, and he said, just imagine how it feels if one day you wake up and you realize this is not only the city of Tulsa, this is not only the state of Oklahoma, but this is a reservation, an Indian reservation. He was like, we were scared. We didn't know what to do. And I thought, huh. And then it became my turn. I said, okay, here's my perspective, and many other Native people, that imagine you wake up one morning and it isn't just the city of Tulsa. It's not just the state of Oklahoma. It's the Muskogee Creek Nation Reservation. It is that realization of everything our ancestors talked about, of all of those promises that were unkept, and the lies and the attempts at genocide at our people. All of the boarding school attempts to kill the Indian, but save the human. And today, July 9th, 2020, all of those realizations became true, it is a good day to be Native. It is a good day to be on the Muskogee Creek Nation Reservation. And we had several people jump up. It was like, yes, it is. And that's our perspective as we look at this, and the way we feel. And I get excited even talking about it because it was historic and it is historic. Oh. Now, here comes the reality. Since that time, I have many of my jurisdictions, municipalities and counties, who flagrantly um, do not comply with the United States Supreme Court decision. The city of Tulsa is a good example. Um, they are withholding traffic tickets. Why traffic tickets? Um, Me personally, I think it's because traffic tickets are a moneymaker. It's easy. You just issue a ticket and people pay their fines. However, the city of Tulsa is withholding all traffic tickets to natives within the reservation. As a result of that, there was the case of Hooper. And in Hooper, who was a Choctaw citizen who got a ticket in the city of Tulsa, he said, wait a minute, you're not supposed to do this because of the the recognition of the reservation. We took that case to the 10th Circuit, and the 10th Circuit federal court said, city of Tulsa, you cannot do this. You cannot withhold traffic tickets. Now, what they had argued was a pre-statehood um, Curtis Act. The Curtis Act basically allowed Arkansas law to be used in Oklahoma before statehood because Oklahoma wasn't quite organized. And in 1907, Oklahoma became a state. However, the city of Tulsa said, that Curtis Act where we used Arkansas law, it still applies here. And basically, it kind of a foolish attempt. However, all of that saying, the 10th Circuit said, no, Tulsa, get with the program, hand over the tickets to the Muskogee Creek Nation. After that decision from the 10th Circuit, we realized we were still not getting the tickets. And at that point, I filed suit against the city of Tulsa, the mayor individually, the chief of police individually, and their lead attorney individually to get the attention to say, come on, the Supreme Court has said so, the 10th Circuit has said so. What seems to be the problem? They, to this day, still refuse to abide by, and have even said as much that the 10th Circuit federal court does not have authority over Tulsa or over Oklahoma. And I don't know what law school they went to give them that background, but it clearly flies in the face of what we know as the jurisprudence and the laws of the United States. So, not with the pending litigation at the federal district court that I have filed against the city of Tulsa, therein comes another case called O'Brien. O'Brien was just released earlier this week or last week. I've kind of been in trauma since then. It may have been last week. The Oklahoma Court of Criminal Appeals took a look at O'Brien and said, you know what? We find that the city of Tulsa and the state of Oklahoma has concurrent jurisdiction over Indians. Now, that is a very first in federal Indian law. And it is federal Indian law for a number of reasons, not only to mention congressional plenary power, the constitutional delegation of congressional authority over Indian affairs, but it is again smack in the face of what happened with the United States Supreme Court decision of McGirt, the decision of Hooper, and everything else we understand. So now we have O'Brien to contend with. O'Brien reflects the a significant attitude of what we have on our reservation. And I would be reticent to say that it's only in the Muskogee Creek Nation Reservation. We have a lot of pushback. We have a lot of commentary that goes on social media saying the Indians don't know how to run the cases. They don't know how to do this. Do they have attorneys? Do a lot of a lot of commentary that is racially tinged and condescending. So, um, so that's a lot of what we are dealing with. There, in the middle of all this, there was also you may have heard of Castro Huerta. Castro Huerta was a case where a non-native was severely abusing uh, a Cherokee little girl. I believe it was either his stepdaughter. Um, it was a non-native who was committing a significant maltreatment case against this Cherokee child. And the Supreme Court, with Justice Kavanaugh writing that opinion, said that there was concurrent jurisdiction with the state and with the federal government over non-Indians committing crimes against Indians. That was a brand new step into federal Indian law as we understood it. So not only are we navigating the obstacle course of federal Indian law and court cases and decisions, but there's also congressional acts that have a significant impact. The Muskogee Creek Nation, as of 2013, we instituted and implemented the Violence Against Women Act, which gave the tribe specific special authority to prosecute non-natives who were committing violent crimes, domestic violence crimes on Native people. Now, that was instituted in 2013 with certain caveats. You had to have a law trained prosecutor, a law trained defense attorney, and a law trained judge. Fine. We have that and then some. But in 2022, Congress recognized that not only are these violent crimes being committed in the perspective of domestic violence. When that happens, there's usually violence against the children, there's violence against others. So in 22, there was the expansion of the VAWA statutes, which allowed us to criminally prosecute anyone who commits a crime against a Native child. And then there are other expansions, any assault and battery on a justice official. So we have taken the opportunity to stand up those opportunities from Congress to expand our criminal jurisdiction. We have done so. We also work on our own criminal statutes to make sure that we implement best practices. For example, I believe it is within this year, the Muskogee Creek Nation, I believe we are the first nation. There are some states who have done so, recognizing the prevalence of sexual assault that happens in Indian country, with natives being the victims of such violent crimes, and the nature of reporting, of disclosures, that they are delayed. We took and we wiped off of the statute of limitations for reporting sexual assaults, whether it be rape against a child, rape against a woman. So we have taken away the statute of limitations with respect to sexual assault crimes. As a prosecutor, I know that it's still not any different if the crime was committed 20, 30 years ago, 50 years ago, or 2 weeks ago. I know that it's going to be difficult to find that evidence if it has been a significant amount of time. But I think what's important And the message I wanted to send with that is that we listen to victims. We are a victim-centered prosecution. We know the prevalence and the victimization that happens and the vulnerabilities in Indian country with the jurisdictional quagmire that exists. We wanted to not only recognize that, but I mean, if you look at behavioral health and are the reasons that one would have a delayed disclosure, fear, retribution, shame, all of those things. Let's take that out of it. And just so we have implemented that. And as a 20-year violent crimes prosecutor, I'm excited about that. But I'm excited about how we can continue to have our laws not only recognize the reality of this, of violent crimes, but be responsive to what's going on. Technology facilitated crimes, exploitation of not only our children, but also elders and the abuses that can go on. However, we can't do it alone. We have we have 11 counties on the reservation of the Creek Nation. We have cross deputization agreements with 9 of them. We kind of have workarounds. What I realize is that at the end of the day, the majority of this is on relationships. If I know I can trust you, if I call you and I say I need help, there's this unarmed standoff, I need help, I need backup, there's a case going on, we need some information, do you have? It's about working together, because again, at the end of the day, we all want the same thing. I want my kids to go to school and feel safe and confident that they're learning how to do math and how to read and do art, instead of how do we respond to an active shooter situation. We all want our kids to have that safety and security, and the sheer joy of being a child and innocent and free of all of those worries and concerns. I want our elders to be able to walk down the street and not have to worry about an assault, about being abused. And if something does happen, that a jurisdiction who has prosecutorial authority will investigate it fully, and there will be justice. That's no different, regardless of what color you may be, where you come, how you worship, if you worship. We all want those same things, and I only believe that by working collectively, we don't have to like each other, but I want to know that if I call for help or if I need help with an investigation, that my law enforcement and prosecutorial partners will respond, that we understand and recognize the rule of law, which all of us recognize under the supremacy clause. The United States Supreme Court will hand down decisions that we're all bound to. There are no exceptions. But I'm regularly coming across these, and those who have been sworn to uphold the law cannot be the ones who pick and choose what law they want to implement or ignore because they're upset at a Supreme Court ruling or they don't want to turn over a suspect to the tribe. Um, and that's a lot of what we're looking at in Indian country. I hope I haven't taken up too much time and I can leave some time for questions, or I forgot to set my timer when I started. So
That's all right, Jerry.
I hope that, and
Amazing.
I hope
Thank
that
you.
was able to make sense. Thank you.
Yeah, absolutely. And it's a good overview. And we appreciate the comments. We'll hold questions for after we've heard from Trenton. So Trenton, I think if you could tell us a little more sort of about the enforcement and the environmental work that you're doing there in the Quapaw Nation, that would be a nice compliment to what we just heard from Jerry.
Right, yeah, and for everybody listening, I'd like to give a little context to that on the history side for us, and I'll try to share my screen here for some visual aids and see how that's going to work for us.
I made you the co-host, so you should be able to share your.
Awesome. All right, so let's see if I can get this going. All right, can everybody see that?
Yep.
All right, perfect. So as Attorney General mentioned, the Quapaw Nation has historically, as you can see here from this rendering of the 1818 treaty succession, that's basically what that was that first treaty where the Quapaw Nation ceded land. And then if you see the blue arrow, it points up there in the very northeast corner of Oklahoma, which is what ultimately after 1833 was established and where we currently reside and have, as the Attorney General mentioned, a ruling on our recognition of our reservation boundary. So from that, it was a lot of back and forth. As mentioned, removal happened for us multiple times. We went back and forth because we was kicked down and flooded land and crops, and where we was established, the main base is where the Arkansas meets the Mississippi, and that was very rich farming land, and where we were moved to was not. So the tribe was just numbers were just wiped out from removal that really hurt the tribe as a whole. But from that, so we were pushed up in that northeast corner, and it was a very rich area for lead and zinc, cadmium. Those were the mining occurred here. This is portion of, you can see Newton County over there in Missouri as the tri-state mining district. And they began mining as early as the late 1800s here. And that ran from that period of time up until as late as the 1970s. And like I said, that being primarily lead and zinc is what they took from the ground. And this kind of shows you kind of some of the underground mine workings. And from ours, Joplin, Missouri is about 30 minutes from here. And during the height of the mining, you could go underground here in the Pitcher Cardin area, which is in our western side of our reservation boundary, and you could drive underneath and never come back up until you got to Joplin, Missouri. So from all this mining that you can see underground here, they took out that to get the ore of the lead deposits and things. For about every ton of lead, they created 16 tons of this mining waste. So there's a picture now of the chat pile that is the waste byproduct of that mining. So it was basically crushed. You can see kind of on the left side of this picture, a darker brown pile within that light pile right there that's some bull rock that's not crushed down and processed as much as this fine tailing. So over the course of time, they refined how they extracted those heavy metals, and so they would reprocess this. So as they reprocess the chat to extract that metal, your waste byproducts from flotation ponds and things of that nature really became dense in some areas where the lead is, we have established, or EPA has established eco levels that's acceptable and residential standards that are acceptable for how much compared to background, how much can be out there and be hazardous to for ecological reasons or residential purposes for living, because lead is, as everybody's knows, that's why you have to have they always ask you when you're buying a house if, you know, it was built before 1978, lead-based paint, was it used or not? Because that's, you know, it's problematic for young children development, and women being pregnant, you know, can cause birth problems. So this was heavy in basically our entire western half of our reservation boundary. So we have it's 40, basically 40 square miles of an undefined boundary because this stuff was kind of used all over the place. But we've been operating, let me get kind of back on track here, just to show you, I'm getting a little bit ahead of myself, but so here is Tar Creek, is the Tar Creek Superfund site is what, you know, it's the largest Superfund site in the country. You see this orange water that is, you know, not very appetizing, but, you know, the tribe's goal, you know, we've been left with this. This is where we are. We don't have, you know, another place to go to. So the Quapaw Nation has taken a big step forward in taking, you know, responsibility for cleaning up. This is our land. This is what we have. We are going to be here far past me and my grandkids. So looking down the road for future generations, we want to get this restored back to a healthy state. And we're doing things that, you know, we were the first tribe in the country to self-perform remediation actions on our own land. And so the Tar Creek there, that's the spotlight of the Superfund name here, that's caused through oxidization of the mine waters. So as those mine levels of the water, because they had to be pumped out daily. There's a building that's still up that was basically the power plant that operated keeping the water out while they mined all those years. And as soon as mining was shut down by the 70s, those all filled back up with water. So as that water table increased and decreased, every time it would raise, it would push out those heavy metals that is oxidized and caused this rust color in there. So through EPA Region 6 General Assistance Program, the Quapaw Environmental Office was basically, we got established in 1997. And 98, the tribal chair and EPA Region 6 administrators signed a tribal environmental agreement, which established a formal agreement between the tribe and EPA to address issues raised regarding environmental protection of lands within the Quapaw jurisdictional boundaries. And so through we're administrating an EPA Superfund Management Assistance Grant under an existing Superfund Support Agency cooperative agreement. So we entered into that support capacity in 2001 to have meaningful and substantial involvement in the decisions related to implementation of remediation actions of the Superfund site. And so working with EPA and stakeholders on Tar Creek issues basically over the past 20 years has allowed us to create the technical capacity needed to self-perform this work. So basically by 2013, the Quapaw Nation took on our first self-performing cleanup. And that was on the Catholic 40 site. This is a picture of an adjacent site next to that area, which the Catholic 40 was where the Catholic mission, St. Mary's, had a school, a shoe building shop, and a church. Then they deeded that back after the school and everything closed down. The church was gone, I think around 1927 or so. The the church leased that property out for mining. And so then we were left with, another site. And this was the first one that, we took over to do the remediation actions on. And so this was basically, we started here, and moved through interagency agreements. We started self-performing all remediation actions within our tribal jurisdiction. So we work with EPA and ODEQ and self-perform all of the remediation within our jurisdiction. So if you see here, basically our jurisdictional boundaries roughly 56,000 acres. You can see kind of the spots, that is all surface chat, and this is a picture from 2024. Yeah, actually, just today, actually, I pulled this off the website. So that's still surface chat that's remaining. And so the EPA has broke this out into operable units for cleanup, and OU4 is surface chat, and that's still, you can still see all that. And what is not depicted here clearly is basically Spring River runs on our kind of the eastern central portion of our jurisdiction. And we started cleanup basically over in that area. That was the Catholic 40, and we worked towards that core area where you can see the land still being scarred. And it's moving very, very quickly since we've been able to take over and perform this work. There was times that there's a byproduct of that mining waste that I showed you on, that was the piles of chat. That's an approved use for it is for roads. There's some bridge decking and stuff that's other that can be used as well, but the main thing that goes back into is roads, because the flint that is crushed down and basically it's just chert. As long as it's encapsulated, it's an approved use that it doesn't leach out and cause harm elsewhere. It's a very hard rock, so it holds up better for skid resistance on roads than limestone does. So processors have went back in now, not after extracting heavy metals, but to pull that byproduct off for construction of roads. And for a time, there was a moratorium put in place over on restricted chat. So chat that wasn't associated with the federal government or as being an asset, a trust or restricted asset, could be sold, and people profited from that, whereas the tribal chat couldn't be for some time. We were able to get that lifted, and so now we can, per the record of decision for this site, they wanted 80 to 90% of the chat removed from chat sales. And has been millions of tons out there and still yet to be cleaned up. Since we've taken the lead, on these remedial actions, we've removed or kept in place over 8 million tons of waste material, which resulted in the cleanup of hundreds of acres so far being put back into mostly agriculture use here for us. And so here's the Catholic 40 that I mentioned, kind of a picture of what the site was covered. It was 40 acres, what it kind of looked like before we got in to do remediation, and then what it looked like after remediation was complete. And that's the rock down here, that's limestone that was brought back in, crossing what is Beaver Creek that runs through that and actually goes down through our powwow grounds, just down the way. So this is a culturally significant site here for us, not only historically, for what took place with the Catholic school, but where these waters run through, the grounds, and where I grew up, in that water play, and not realizing that, probably shouldn't have been doing that, those things as a young child. But let me get back off. Sure how to remove myself from sharing. So it's been a from all that work. So you have things that we can't address completely. So you have subsidence features because of all that mining underneath the surface. You have mine shafts that come in and have to be monitored and kept in place. So we had a problem because this was should have been under the management of the Bureau of Indian Affairs when this all took place, and all this mining waste that was left on trust and restricted property. Now we're kind of left to get it fixed. But if anybody's worked with the Bureau before, it was problematic trying to get, early on, I was involved as the realty director on remediation of some of these sites before the tribe took over. And, they pushed in some of these subsidence features with material on site, which, wasn't so much of a problem, but it was capped in place along, some creeks and tributaries that created a nice looking rolling hill that you have to be able to identify in the outside world. ODEQ would have just went and filed a deed restriction on that. So it always shows up through any sort of title record that, there was work done, there's something out here, you need to be mindful of this. You can't disturb this area of the property. You can't drill a well, build a house, whatever that may be. On our side, we didn't have a mechanism for that because, when we're trying to get the Bureau involved, that's a taking, that they're supposed to be there to prevent and protect that from ever happening. So the restricting of land was kind of, we had to work around how can we achieve what we need to, because in 50 years, when I'm no longer doing this, who's going to remember that rolling hill out there is not a good home site? And so basically what we ended up doing was establishing conservation easements for areas that were still left impacted after cleanup. So if we had to consolidate or restrict, or there's a mine shaft or a subsidence feature or material left in place on that property, we defined that, filed it as a conservation easement that always shows up on our title status reports, which is basically our deeds for the restricted property. So that on that encumbrance page, it's always noted there's perpetual conservation easement that runs on that property. So now when a landowner gets that and wants to develop on their property, they can look at that encumbrance page and see, oh, okay, we have something here. So that took a lot of work to get that accomplished and get everybody on the same page. Like I said, we had to deal with EPA meeting everything that they needed on these restrictions and satisfactory to the Bureau on how they could get through it. And from those, we've had places, because mining was so prevalent here, they had to process that. So we've had smelter sites that we've came in and took ownership of to expedite cleanup, because there was, people just didn't know if stuff wasn't filed before, and there wasn't any means or reason to file anything before because there wasn't really any oversight. So we had a smelter site where a family had moved in and was causing elevated blood lead levels for and a child, that we basically came in through assistance with EPA, did the cleanup. EPA did a buyout of the Pitcher Garden area, and this one came at the tail end of that. And they basically asked us to come in and help out. So that family got relocated, and then we restored the property, cleaned it back up. So, you know, we've stepped in on a lot of those, or we have on a lot of those properties. So from that, the tribe's been very open to, you know, wanting to acquire those properties, even though they are problematic, to get those cleaned up, for the not just tribal community, but our community as a whole, to be able to have a better place to reside. And let's see if the business committee right now is really, really supportive of trying to push our waterways, water quality standards, all our environmental issues, to really push to restore and establish. And through our relationships with EPA, ODEQ, you know, they've been very open and understanding of, you know, cultural uses, and being able to let us try to reestablish some of these like riparian areas for culturally significant plants and gathering and things that still go on here that the general public doesn't see, or even know about. And some of that they don't need to, but you know, that it has to be taken into account for us as a people to continue to exist as we have and will continue through the years. But I think that overall is, I mean, I could spend hours talking about all the things that we've hurdles that we've had and done, but it's a really hard site to show you from a satellite view. When you come here, especially this time of year when there's not a lot of tree foliage and growth, it's a huge undertaking. And as I mentioned, you know, it's the largest Superfund site in the country, and it's going to continue on over the next 20 or 30 years, just trying to get everything reestablished. And as the Attorney General mentioned earlier, it couldn't continue without good relationships with other agencies, local municipalities and governments. And within our reservation, our tribe's been very open to assisting those. So she mentioned their light horse. We have our tribal marshals. They are the policing department for the city of Quapaw within our reservation, the city of Commerce within our reservation now. We've taken over both of those, which are the two existing towns, Pitcher and Garden. They were all bought out through a voluntary buyout through a agency basically funded by EPA. So those towns are no longer in existence, but the tribe from those took over the water system, and we still service, I think, 12 or 13 residents. So we manage that Pitcher water system as well. But I think that's I am open to any questions that anybody may have in regard to any of that. And I hope I did it some justice on explaining that stuff.
Yeah, thanks so much, Trenton. The scope of that project is just mind-boggling. So, all right, journalists, you know the drill. Let us know you have a question in the chat. And thank you for that, Trenton and Jerry, both of you. And I'm sure we will see a big string of questions come in right now. And it looks like Layla was the first one. on the list. So Layla, take it away.
Thank you. And thank you, Trent, for that kind of horrifying overview of what's going on your Superfund site. I live on close to one too in Brooklyn, the Gowanus Canal, and knowing how complicated that whole process has been, I'm super curious to hear how a Superfund cooperative agreement works for you guys, what sort of oversight you have with EPA and some of the other agencies that might be responsible, how much agency do you actually have and all that.
Right. So, yeah, we work on these. So basically we have it's all through funding through the EPA. But we have basically two different sides to it. So if it's on trust or restricted property, we deal directly with EPA, and work with their contractors on site plans, development, and things like that. So we report directly to their regional project manager. And so we have at least biweekly meetings or monthly meetings with them, that are set up reoccurring between our environmental office, who does basically our oversight of the work, and then through it's a government to government type of agreement. So we have our remediation arm of the tribe, which is Quapaw Services Authority, that is doing the work out there. So then we have individuals on that side that does quality control on that side and quality assurance on our environmental side. So between on the restricted and trust properties, it works between the tribe environmental and the tribe remediation and EPA. We stay communicating together to make sure we're meeting the plans as they were set up through our assistance and EPA's experts on meeting the remediation goals. Now, on the state property within our jurisdiction, we work with EPA and ODEQ, within the Oklahoma Department of Environmental Quality, as they're basically doing the quality assurance for EPA, and we work with them on that. So we all work really well together. So on Fridays we have calls with ODEQ, making sure we're staying up on the state projects, and that they're going the way that they should be. And then we have separate calls with EPA, and then we have calls where all three of us are together. So
Thank you for that.
All right, thanks. Ashley. Hello.
Hi. Can you hear
There you
me?
Yes.
Just living in like the technical troubles over here. Trent, my question is for you. Thank you for sharing your knowledge with us. I was wondering if you could expand on what your hopes are for returning Tar Creek to what you called a healthy state, as far as like your specific ecological or public health goals. You talked about remediation goals throughout your presentation, but I was curious which was for Tar Creek specifically.
Right. So, as the Attorney General mentioned, we have a checkerboard effect up here as well. So the majority of the Tar Creek remediation side that's on trust or restricted land is still held. The title is not solely the Quapaw Nation. It's mixed between tribal member ownership, and some of that's even came out to be more problematic. So we have 100% ownership in a tract of land. Well, 30% of that may be taxable fee interest, 70% divided up between 50 or 60 individuals, and then the tribe being one of those. So what we're restoring the land to is, we have a repository that's on tribal property where we're trying to consolidate, because each one of these sites, some of them can be remediated all the way to clean, where there's nothing left, we do our test and everything's gone. However, some sites, depending on what was done historically there, it may not be feasible physically or monetarily to remediate that site completely. So we're reducing that footprint of impacted areas. And so anywhere that we have to leave material, I mentioned those conservation easements, that's what we put in place, but we're trying to create as few of those as possible. So we have a central repository where we're taking the majority of everything. And we've consolidated ownership on that from the tribe, which ultimately will, through ODEQ and us, will have to maintain that forever. But to what the goal is currently in this area, because of undermining, there's not a, we're not going back in there for housing or anything of that nature because just of unforeseen risks that could be there. But we're in a rural area that's mainly agriculture. So we're trying to get those back into at least the state where, because the majority of them right now are still being farmed all the way up to a chat pile. So some of the problems that have came along on the state side where they're trying to get access to do these cleanups is from that chat pile that I've showed you pictures of, over rain and time, contamination has seeped out from those piles into the soil. And we just call them transition zone soils. So they still may have an elevated levels of contaminants that have to be removed. So it's kind of a hurdle right now is getting farmers who rely on that for their livelihood to buy in and allow cleanup when their soil's getting stripped. And it may be on a site where, we can't get a pond built to use that as borrow to backfill. So there's all kinds of hurdles with each site, but the goal is to restore it mainly back to agriculture. So it's at least in production in some way, or back to, in the future, maybe some wetland areas that's a little safer. And then, like I mentioned, just being able to go back for, culturally significant plants and things like that for the tribe itself.
Thanks,
Thank
Trent.
you.
Okay, so Maura's next, but the question after that is for Attorney General Wisner, and I wouldn't mind giving Trent a chance to catch his breath here. Maura, is your question for Trenton or for Jerry?
For Jerry.
Oh, all right. You're catching a break here, Trenton. All right, go ahead.
Yeah, I have a question about the McGirt decision. I'm just curious if it's opened up points of tension or dispute between the tribe and say the city or state in areas outside of criminal justice as well. If there are even say individuals who have seen the decision as a way to press tribal interests in ways outside of criminal prosecution and jurisdiction. And I'm just curious of any anecdotes you might have or information of ways that the decision has influenced the tribe and its interests outside of, yeah.
Well, one of the things that we look at is that the restored jurisdiction and the recognition of the reservation, the laws that apply to each are significantly different. If you had allotted land and it's checkerboarded, as we talked about, versus a solid intact reservation, it's significantly different. But if you have, it impacts. We have a tax case pending before the Oklahoma Supreme Court, which allows a tribal member who works for or receives their income from a tribal entity, and they are a member of that tribe, and they live on the reservation, then they are exempt from state taxes. the state says no, and they're doing legal gymnastics on trying to get those implemented on our reservation. So I wouldn't say there's a new expansion, as I would say we recognize that with a reservation there are different applications of law, and so we are fully implementing that. I think that with sovereignty, it is I give the analogy, it's like a muscle. If you don't use it, if you don't exercise it, if you don't protect it, it will atrophy. And the we've seen several court cases where the decisions, the opinions have been handed down because you didn't utilize it, because you didn't act like you had an intact reservation. That those practices will be used against us. So we are, to the fullest extent possible, treating everything that we have, looking at it from a perspective of, is it on the reservation or is it not? Trenton mentioned, the ongoing difficulty. It is extremely complex when you start looking at the ownership, and there's still trust and restricted land. What we want to get to is a point where we say, is it on the reservation? Is it off the reservation? Period. We've got hunting and fishing agreements between all of the tribes. I think instead of looking at it as it's in a new expansion, it's the full recognition of what should have been implemented in the first place. And so we're looking to regain that ground that had been significantly lost, and we look at it with a full 360 perspective, as opposed to just a small little blinded view of what we have. We're looking at it with eyes wide open.
Thank you.
Excellent.
Thank you.
Thanks, Jerry. Legia, you have a question.
Yeah, if it's okay, I have two questions, the second of which I think the answer will probably be short. Maybe I'll put myself back in the queue afterwards.
Let's see how it goes. Take a shot.
Okay, sure. So Attorney General, I wanted to ask a question touching on reparations. My family, my grandmother's parents moved to Oklahoma when it was still called Indian Territory and settled in Muskogee, where my grandmother grew up. And I wonder what the Muskogee Creek Nation, either as a people or you as an individual member, would want from people who, lived on your reservation, profited off of being able to live there, occupied your land essentially. What would, again, you as a nation or you as a person want in terms of reparation, recognition, anything under the sun?
Thank you for that question. And I say this, sharing this. Let me throw out this caveat. In Indian country, and Mr. Stan may have a different perspective, but as I see this, as I know is a general practice with the Muskogee people, this decision is for the collective, and we as a tribe are looking at it from a government to government standpoint. Yes, there were other infringements, there were other takings, there were other violations as a result of federal and state violations. So they're the ones that actually are responsible for those incursions. And the responsibility would be to the Muskogee Creek Nation. And we would look at it that way, as opposed to individuals, because it's only as a collective, as a tribe, that we have this land, and is the name for the land. And we tend to try to get away from, it is historically and traditionally, we didn't look at ownership or as possession as an individual right. So so it would be a government to government relationship and response and answer to your question. I would think I would tend to lean that way as opposed to the individuals, because the individuals didn't really have the rights without being under one of those umbrellas.
Thanks so much.
Whoops. Odette.
Hi, this one is for Attorney General Jerry. Because you've spoken on jurisdiction, I live north of the colonial border, and so I'm really curious about Savannah's Act, the bill aimed at collecting data for murdered and missing Indigenous women and girls. Has that bill, in your opinion, improved tracking and responses? Or maybe you'd just like to share your thoughts on recommendations on how jurisdiction issues could be addressed or improved?
Let me follow up. Are you asking this with respect to specifically like the MMIP, MMIW response? Well, the Savannah's Act, and I have to go back and read it, but right off the top of my head, it doesn't necessarily, I haven't seen any significant results. I haven't seen that has been a great improvement. One of the realizations in Indian country is that there is such a wide range of guessing and data because it doesn't exist. When we don't have to report to anyone, and it's kind of like saying, well, you're not the boss of me. So the state regularly has their own reporting mechanism. The feds have their reporting mechanism. And unless we have a grant that we agree to report, then we're not going to be, tribes tend to covet and protect that information because it's often used against us, or it's used by the state to help support their numbers or their claims for something. I do want to share this, though, with respect to MMIP, missing and murdered Indigenous people, Indigenous women, how Indigenous relatives, whatever that caption and name may be in that area. The United States, just a couple of years ago, put out, I believe it was still under then President Trump, it was Operation Lady Justice. Operation Lady Justice was a lot of federal funds to go into Indian country to train Indians how to keep up with their people and how to find them and how to do all this. And to that, I think that is just such a misguided perception and response to the reality. Indian country, we know where our people are. We will not hesitate to form a posse and go looking for people. Here's the problem. Our people are going missing on state land away from the reservation. And when a report is made, the response is, it's just another drunk Indian. She's just out partying. She'll be back. And the cases sit on the county sheriff's or the city chief of police desk, and it goes cold. That's the problem. And when the feds have money and they put it toward this, they want to come down and browbeat Indian country that we don't know how to do it. I challenge you on that, because the reality and the numbers would show that it's in the state jurisdiction off of Indian land where our relatives, our women, and our elders and our men go missing, and they're not given the same attention and follow-up and investigations as other missing reports. Thank you for your question. I hope that helped.
Thanks, Jerry. Robin.
This is a question for Trenton. I've been to Tar Creek and written about it. It's absolutely the worst place I've ever seen. I hope you get it clean. My question is, when you were talking about families with children exposed to lead there, you talked about relocating the families and cleaning up the land. Is there anything you can do for the children?
There's a local a local group right now that offers, and it's through the state side, I believe, that, and I know it is, on some regard, because there's a program still ongoing where ODQ, under, I think it's OU2 operable unit, it's a yard remediation, and they're allowed, families that either have questions, concerns, they can contact them to come in and have their yard sampled, or, and that's still ongoing outside of our jurisdiction into the Miami area. So there is an avenue for them if there is concern, or to get further addressed that way. But also locally, I know when my son was born in the Miami hospital, and it was offered at that time, do you want to participate in blood lead monitoring? And so, we did that with him. So there are options for folks that have concerns, if there are children with elevated blood lead levels. And then, as far as I can tell, the state's doing a pretty good job at, trying to find mechanisms to help address, that family's need. And then, like I said, that was the one rare instance where they already came through with the buyout because they understood in the Pitcher Carden area that there were a community with elevated blood lead levels. And so they gave them the option, to buy out. And then the ones we helped was kind of after that fact, that moved in not knowing, or either didn't have somebody look at the title documents or go through it well enough when they acquired a piece of property to know historically what had gone on there, that old building wasn't just an old outbuilding, it was an actual smelter spot. So that's the one that we helped in after the fact. But yeah, I think everybody collectively as a community is willing to help those where we can.
Thank you.
Mhm.
Okay, thanks. Hector, you have a question.
Actually, I'd like to skip my question, but I did want to say thank you, Jerry, and thank you, Trenton, for sharing all your information.
Thank you.
All right, we're back to Legia's second question.
I'll go quickly. So I had a question for both the Attorney General and Trenton. I'm curious what your nation's relationships are with your ancestral land, the land where your people lived before removal.
Go ahead, Attorney.
Sure, thank you. We in Macon, Georgia, our people originally came from the Georgia, Alabama, North Florida area, and the mounds. There is a Macon, Georgia. There is a national park that we are looking to do a co-conservatorship. There's also a couple of places in Alabama that we have talked, we are in discussions with them because we have tribal towns. The tribal towns were like small tribes that were all under the umbrella of the Muskogean people. So we still have our ancestral remains. We know where those grave and burial sites were. We know where those ceremonial places are. And so being able to protect those and seeing and working with the state and potentially congressional legislation to be able to protect those is something we're extremely interested in. And NAGPRA would apply in those cases, so we can have laws to be able to, even though we have been removed, that still doesn't negate the fact that I have ancestors who are buried, and we would like to see, just like everybody else, we would like to see that they remain so. Thank you.
Thank you.
Right, but along those same lines, our Tribal Historic Preservation Office is very active in the former reservation and former lands in Arkansas for us. And we've done kind of the same. We know we've acquired some land by the port over on the west side of Mississippi where there's some mounds, historic sites, things like that we've acquired, and we're actually in the process now of, with the new feed of trust regulation changes that went into place this year, trying to get that put back under our jurisdiction to have a little bit better control of that stuff. But our TIPO and our NAGPR office, they work a lot trying to make sure that our sites are protected back home. And I think it's getting some information out there. We don't want sites just publicly available, but is just getting information to folks to not tie it to something archaic as to tie it to people that are still here, because nobody wants anybody to to go down to a cemetery and disturb it and build something on it, to tie it to people today, and that it's still our folks that are back there. So just some education and getting maybe a different line of thanking for people, that it's not some Raiders of the Lost Ark type mentality where they're grave robbing things to that nature. So we're actively working daily trying to preserve those things.
Thank you.
Yeah, thank you both for that. All right, Chris, it looks like you might be bringing it home. So,
well, thank you so much, and thank you both for sharing the challenges that you're facing right now, that weren't your problems to begin with, and I'm sorry about that. I'm in Virginia with the Virginia Center for Investigative Journalism. We have we have 2 tribes right now that are looking for federal recognition, and 7 now that have it. And they're all in some form of working through land back. And in talking to several different leaders, and I have many more interviews to go, but one of their concerns is around housing. And I'm just curious how maybe that's changed specifically in Oklahoma with on the reservation lands that are in the baking industry, and how, what that looks like, what challenges might be existing that you're facing.
I'll take a stab at this. I think that we are facing a lot. So if would I be off base if we're talking about homelessness or
the concerns
housing?
are, sorry, here in Virginia anyway, and I don't know if these are shared, is the expense for land, and actually being able to have property on there's 2 of our, we have 2 reservations out of all of our nations that have federal recognition, and many are trying to get their land back through a lot of different means. But one of their challenges, I think, that they're talking about is the cost to then build on that land, or to do whatever they want to do on that land, especially around housing.
I think that the cost is probably significantly different from Virginia and Oklahoma. However, if you look at the cost of living, is going to also be in relation to what your income is. I wouldn't say that that's necessarily a problem in itself in a vacuum. I think there are other issues that are contributing to this, not only the cost, because we have a significant homeless problem or housing problem in and around the Tulsa area, and also, it is, we're seeing it more so in many of our rural areas. But there also is behavioral health, mental health problems, the issues of drugs and substance abuse that contributes to those rates. So I don't know if I'm in a position where I would say that the cost itself is the sole contributing factor in that. But it is a significant factor, and that there's not enough, and trying to find adequate housing in itself is a difficulty.
Yeah, and I can co-tell a little bit on the Attorney General's statements there too for us, because cost is somewhat of a factor, but for us here, you know, the Superfund site is a large factor for us just because it takes up so much of our jurisdictional land. And so funding from, you know, if a tribal member tries to go to a bank to get funding for that, you know, they're not going to do it within the Superfund site. So there's some differences here that limit the ability for, you know, housing to be developed. The tribe is working towards, as my knowledge is, most tribes are trying to provide, you know, as much housing as they can for the needs that they have for their people. And we're currently under development of, you know, 20 houses. Right now we have some elderly housing that's been established for the better part of a decade now, but there are within Oklahoma, and I think it's getting a little bit better on cost, but you know, it was problematic for any community to buy smaller fractional, you know, land with the approval of medical marijuana stuff, because a lot of a lot of smaller tracts were being bought for or prices were being driven up from that, and then larger tracts were, you know, when I first started here around 2009 and 10, you know, we had larger cattle operations that if there was anything 80 acres or more, they were going to buy it. And now the tribe's developed on into our cattle company, so we're able to kind of expand and acquire more property, because now we're not solely just deriving income off of casino revenue, so we're expanded out, so now we can use land a little bit different. So the tribe's trying to, within our jurisdiction, to tie back as much property as possible for the overall benefit of individual tribal members. And through that, you know, housing is in the forefront of, you know, the goals that the business committee right now is trying to accomplish. But costs are there, but you know, and then people would like to come back, you know, home over the course of, you know, time. People had to leave for work and, you know, to provide for their families. That took them away. And so we see people that, you know, would like to come back, but you know, we're rural Oklahoma up here. We don't have any, you know, real major areas, development type housing, you know, inside or outside the reservation, really close to us. So those are some of our factors that we're trying to work through.
Okay, thank you. Before we wrap up, I have one quick question for Attorney General Wisner. How did the Walika Outlaws do last week?
I got my school colors on. They played at night.
Oh, all right. Go Outlaws.
Yep.
All right.
Thank you.
No, thank you both. Attorney General Wisner and Director Stan, we really appreciate all the insight and time you've shared with us. And it's really, really super helpful to understand how things are playing out there. So this is the time where we all do our patented IJNR golf clap and express our appreciation. And journalists, we will meet back here in 55 minutes. Again, thank you both. Really appreciate all your time and expertise.
Mado.
Got a gay.